Good evening, everyone. Number 4, the law and hard-edged questions, hard choices. Wealth inequality, English law's unintended legacy. Quote, in its majestic equality, the law forbids rich and poor alike to sleep under bridges, beg in the streets, and steal loaves. Anatole France.
The Gresham College lecture that you're listening to right now is giving you knowledge and insight from one of the world's leading academic experts. Making it takes a lot of time, but because we want to encourage a love of learning, we think it's well worth it. We never make you pay for lectures, although donations are needed. All we ask in return is this. Send a link to this lecture to someone you think would benefit, and if you haven't already, click the follow or subscribe button from wherever you're listening right now. Now, let's get back to the lecture.
Many of my previous lectures during my 4 years as Gresham Professor have focused on race and racism. But today I want to put the spotlight on class. You see, this is something that we lawyers rarely talk about, but we should. Because law, I believe, is at the heart of class conflict. In hundreds of different ways, the legal system is a daily battleground between the class interests of the rich and the poor. It's the law that defines and enforces property rights, and that punishes the poor for stealing from the rich or trespassing on their land. It's the law that determines how much the rich are taxed and how much is redistributed to the poor via the welfare state. It's the law that determines when a landlord can evict a tenant and how much they can charge in rent. It's the law that determines when an employer can sack an employee and what rights the employee has at work. It's the law that enforces contracts, and it's the law that decides what happens when people cannot pay their debts. All of this has deep ideological choices. They affect the balance of economic power in our society. For centuries, English law has been a system weighted heavily in the favour of class interests, the class interests of the rich. The class character of the English legal system was particularly stark during the 18th and 19th centuries. And as I described in one of my previous lectures, during the 18th century, hundreds of minor offences were made punishable by death. This wasn't just about being tough on crime. It was about promoting the class interests of the rich within the incipient capitalist system. In the wake of the South Sea bubble, England's first great stock market crash, and amidst the process of enclosure of rural land that left many labourers landless, Parliament passed the Black Act of 1723, which imposed the death penalty for many offences connected with poaching. Writing in Counterfire, Dominic Alexander states, quote, "This was nothing less than a class war over the use of rural resources and an unsparing attack on the traditional rights of the poor and even the middling ranks over resources in the woods, streams and fields of England." Alexander adds, "The enclosures, those countless acts of class robbery that privatised common lands, was already well underway, but they were only a part of the relentless drive to transform a subsistence economy into a market-orientated one. it was underpinned by new legal ideas. Lawyers had become converted to the notions of absolute property ownership. The result was the gradual impoverishment of rural labour and the driving of people into low-wage industrial employment. The foundations of the Industrial Revolution lie here, end quote. As Simon Farley describes the Black Act, without doubt the most vicious, repressive legislation enacted in Britain in the last 400 years. This act authorised the death penalty for more than 50 offences connected with poaching. The act stayed on the statute books for nearly a century. Hundreds were hanged for the crimes of feeding themselves with wild meat. And when the act was finally repealed, poachers were instead transported to the Antipodes for even minor offences. Another historical example of patent class warfare on the statute book is the Poor Law Amendment Act of 1834, which forced destitute people into the workhouse. Conditions in the workhouse were deliberately intended to be worse than conditions of the working poor. As Ian Ferguson writes, the 1834 Act was one of the earliest measures aimed at instilling labour discipline in the new working class. He explains the core principle of the Poor Law, the principle of less eligibility, was aimed at disciplining the working class by ensuring that the alternative to working, the workhouse or poorhouse, was so awful that workers would accept any jobs and any conditions. As one of the Poor Law Commissioners put it, Sir George Nicholas at the time, quote, "I wish to see the poorhouse looked to with dread by the labouring classes, and the reproach for being an inmate of it extended down from father to son. For without this, where is the stimulus to industry?" Similarly, the philosopher Jeremy Bentham, who developed the concept of less eligibility, according to which the poor relief should always be set at below the level of the income of the worst paid, argued that, quote, "Only the cheapest fare should be served in the house. An ample fare might be served only if it did not render the condition of the burdensome poor more desirable than that of the self-maintaining poor." Now, you might think that these examples belong to the distant past and that the class character of the legal system is different today. But we can see many of the same patterns playing out again in recent history that we've all lived through. Most of us remember the 2008 financial crash and the Conservative Liberal Democratic coalition which came to power in 2010 and imposed a vicious regime of austerity, making the poor pay for the crisis caused by the rich. We can see real parallels between the 1834 Act's policy of less eligibility and the welfare policies of present day. Universal credit claimants are not given enough money for a dignified existence and are threatened with benefit sanctions if they don't comply with requirements designed to force them into work. We've seen governments wage war on poor families through policies such as the 2-child limit, the bedroom tax, and the benefit cap. Like the 1834 Act, this is class warfare designed to benefit the rich by creating a pool of easily exploitable labour. nor has the state stopped using the criminal law to repress those who threaten the class interests of the rich. Most of us will remember the harsh punishments meted out after the English riots of 2011, following the shooting of Mark Duggan, which included a 6-month prison sentence for stealing bottles of water worth £3.50. And while Parliament has passed legislation repealing the Vagrancy Act of 1824, an act which effectively criminalised the homeless, the government has yet to bring the repeal into force. In short, all too often, the law is wielded by the rich against the poor. Yet, it doesn't have to be that way. The measures taken by the reforming 1945 Labour government, such as the establishment of the NHS and the welfare state, the nationalisation of key industries, and the introduction of civil legal aid, made life measurably better for the poor and narrowed inequality. Unfortunately, many of the achievements of the post-war decades have been undone by successive Conservative and Labour governments, wedded to a neoliberal ideology, who have wielded the law unashamedly as a tool for promoting the class interests of the rich. So, in this lecture, I'm going to talk about how various changes to the law in the past few decades have widened wealth inequality in the UK and promoted the class interests of the rich at the expense of the poor. I will close this lecture with a few thoughts on what we, as lawyers, can do about it. Housing. I'm going to start by talking about housing. One of the leading causes of poverty and inequality in this country is the exorbitant cost of housing. Many of you will be intimately familiar with this if you're renting your home privately or if you have family members who are. You see, housing in our society is thoroughly commodified. It's a for-profit business in which properties are bought and sold, not as homes, but as investments. And the poor, especially the younger generation, are paying the price. What you may not realise is the legal changes have played a major role in creating our current housing crisis. This housing crisis did not come about organically, and it isn't inevitable. It's the product of the disastrous policy pursued since 1979 by both Conservative and Labour governments, which have undone many of the great achievements of post-war decades. Let's look back at the turn of the 20th century. At that time, many working class people lived in overcrowded slums that were unfit for human habitation. The Housing of the Working Classes Act 1890 to 1900 gave local authorities the power to build publicly owned housing for the working classes, council housing as it became known. They were also given powers to purchase land compulsorily for the purpose of providing housing. The Housing and Town Planning Act 1919, known as the Addison Act, and enacted in the wake of the First World War, launched the first major national council house building programme with national subsidies for council house building. Famously, the Prime Minister, Lord George, promised homes fit for heroes for the soldiers returning after the war. The University of the West of England explains it in its history of council housing, quote, "Planners promoted the construction of new suburban garden estates situated on the outskirts of cities, mainly consisting of 3-bedroom houses for families. The design of estates aimed to create self-contained communities of low density, often with no more than 12 houses per acre." Facilities such as churches, schools, and shops were provided, and houses had large gardens. Conditions were a great improvement over the slums that had previously existed. It was intended that 500,000 homes would be built under that act, although in fact only 213,000 were built. Nonetheless, in the interwar years, there was a substantial number of council house building. Under the first Labour government, the Housing Financial Provisions Act 1924, known as the Wheatley Act, increased central government subsidies for house building. The Housing Act 1930 gave local authorities power to clear slum areas and rehouse residents. To reduce costs, the size and standards of new council houses was reduced in this era relative to 1919, and the University of the West of England states, during this period, a new 3-bedroom house was often only 620 square feet compared to over 1,000 square feet in 1919. But this was still an improvement on the overcrowded slums in which people had hitherto been living. In total, 1.1 million council homes were built during the interwar years. The golden age of council housing came after the Second World War. Clement Attlee's Labour government came to power in 1945. At the time, there was a desperate need for new housing, thanks to the wartime bombing. The Housing Financial and Miscellaneous Provisions Act 1946 provided government subsidies for the construction of new council housing. The Housing Act 1949 removed the previous restriction that councils could only provide homes for the working classes. It allowed them to provide homes for all sections of the population. The Attlee government was hugely successful at building new homes on a massive scale. Around 1 million homes were built, of which around 80% were council homes. That said, there were still some problems. As the University of West of England explains, some of the housing consisted of prefabs, which were intended to be temporary. Do you remember the prefabs? Still many of them around today. And the use of precast reinforced concrete, PRC, which sped up housing construction, went on to cause structural problems in later decades. Still, while not perfect, Attlee's housing programme was extraordinarily successful at reversing the wartime depletion of housing stock and providing decent homes for millions of ordinary people. At that time, there was cross-party support for council housing. Large-scale council housing construction continued under both Conservative and Labour governments in the 1950s, 1960s, and 1970s. As the organisation Shelter states, in 3.5 decades after the end of World War II, local authorities and housing associations built 4.4 million social homes at an average of more than 126,000 a year. Again, it wasn't perfect, As is widely known, some of the modernist high-rise estates built during this era acquired a poor reputation. But it wasn't all high-rise flats. For example, in the 70s, Norwich had the highest proportion of council housing of any city in the country, despite having very few high-rise buildings. Plenty of council tenants lived in houses with gardens or in low-rise flats. And generally speaking, council housing was a great deal better than the overcrowded slums it replaced. Meanwhile, from the First World War up until the 1970s, the private rented sector was tightly regulated. Rent control was first introduced in 1915 as a temporary wartime measure during the First World War. Rent control was gradually phased out during the interwar years, but introduced in 1939 at the start of the Second World War. And rent control continued after the war. As Wendy Wilson writes, in the decades after the war, the private rented sector declined rapidly in both relative and absolute size. She highlights that stock was reduced by sale to owner-occupier sector, demolition through slum clearance schemes, and the acquisition by local authorities. The Rent Act 1957 partially lifted rent control, including decontrolling tenancies after a landlord had obtained vacant possession. And as Wilson explains, this gave landlords an incentive to remove, yes, you've guessed it, sit-in tenants by whatever means in order to charge them higher rents or sell properties. This process became known as Rachmanism after a famously unscrupulous landlord. A little aside here, my parents used to live in a Rachman tenancy in Notting Hill. Back to the lecture. No, an aside. Rachman, despite being an unscrupulous landlord, didn't care about the colour of your money or the colour of your skin. So he was one of the only, despite being a unscrupulous, vicious landlord, would rent to people, ethnic minorities. Now back to the lecture. Despite the partial decontrolling of rents, the decline of the private rented sector, that continued. Wilson states that between April 1951 and December 1961, the sector was reduced from 45% of the housing stock to 25%. The Rent Act 1965 introduced regulated tenancies, under which rents were limited to fair rents, determined by rent officers, and the tenants had long-term security of tenure. These provisions were later consolidated into the Rent Act of 1977. And this type of rent control that many people of my generation remember, and there are still some elderly people who still have tenancies regulated by the 1977 Act. So by 1979, there had been decades of council housing on a massive scale. Conversely, the private rented sector, which was highly regulated, had seriously declined. And according to figures given in Parliament at the time, in 1978, 32% of housing stock in Great Britain was rented from a local authority, while only 14% was privately rented. The latter figure included houses rented with or from housing associations. 55% was owner-occupied. Now, while no one would say that council housing in this era was perfect, it was a huge step in the right direction. Housing policy focused on providing decent homes for ordinary people rather than helping landlords get rich. Then, in 1979, Margaret Thatcher's Conservative government came to power. She proceeded to inflict an extraordinary amount of damage on the British housing sector in multiple ways. The Housing Act 1980 introduced the concept of right to buy council houses. Councils were required to sell their stock, to sell homes at a massive discount to tenants who wished to buy them. They did not have a discretion to refuse to sell. Predictably, this led to a depletion of council housing stock. That depletion occurred not just because of the right to buy itself, but because the financial arrangements associated with it, which prevented councils from using the capital receipts to build more council housing. As the Communities and Local Government Select Committee explained in 2020, quote, "From the outset of the scheme, there was no commitment that the sold homes would be replaced, nor that local authorities would retain all the capital receipts. For the first decade, the government intended that councils could only use 20% of the receipts. Limited restrictions, however, meant that councils were able to spend more than the government intended, leading to stringent controls introduced in April 1990. Section 59 of the Local Government and Housing Act 1989 required local authorities to set aside 75% of the right to buy receipts, which could only be used to reduce debt. From 2004, when the Local Government Finance Supplementary Credit Approvals Act 1997 came into force, 75% of right-to-buy receipts went to the Treasury, with 25% available for councils to replace stock or maintain the remaining housing. Overall, since 1980, almost 2 million social homes have been sold through the right-to-buy scheme. Over the same period, the total social housing stock has shrunk from 5.5 million to 4 million. Another major initiative of the Thatcher government was the deregulation of the private rented sector. The Housing Act 1988 abolished rent control on new private tenancies. From the 15th of January 1989, new private tenancies were either assured or assured short-hold tenancies, and the rents on these tenancies are unregulated. Famously, Section 21 of the 1988 Act, which the government has now pledged to repeal, provides for no-fault evictions of assured short-hold tenancies. Once the initial fixed term has expired, the landlord can recover possession of the property on just 2 months' notice, without having to prove any breach of the tenancy by the tenant. This fundamentally changes the balance of power in the private rented sector, disempowering tenants and empowering landlords. Over the past few decades, it's become immensely profitable to be a landlord. We can see it we're living that right now and I'm sure many of you, those of you in the private sector, know just how vulnerable you are at huge rent increases. Unsurprisingly, many former council properties sold under the Right to Buy scheme have ended up in the private rented sector, a phenomenon that is sometimes called the right to buy to let. With the massive decline in council housing building, the private renter sector has not taken up the slack. Only 174,000 houses were completed in England in the 2022 to 2023 financial year, according to government figures, in comparison to the 307,000 in 1969 to 1970 and the 241,000 in 1978 to 1979. None of this has been put right by any of the governments that have since come to power, whether Labour or Conservative. Instead, the problem has been left to get worse year on year. And I'm going to be perfectly clear here. When Labour came to power in 1997 with a huge majority, it should have abolished the right to buy, reinstate rent control, and returned council housing building to its post-war levels. Obviously, it did none of those things. So Blair, as much as Thatcher, is responsible for the parlous state of the British housing market today. Disappointingly, it is clear that if and when he comes to power, Sir Keir Starmer is going to continue the Blair legacy of ignoring this particular problem. The scale of homelessness in this country is nothing less than a national scandal, as are the sky-high rents that are causing generational poverty for millions of people. In one of the richest countries in the world, there is no excuse for failing to provide adequate housing for all. Employment. Another obvious area where the law affects the balance of power between rich and poor is the law governing employment and trade unions. In the post-war decades, one of the driving forces behind improved conditions for the working classes was the strength of trade unions. When the Attlee government was elected in 1945, its base was the trade union movement. To be sure, there are plenty of good reasons to criticise the Attlee government from the left, but Ian Ferguson, in arguing that the Attlee government, quote, operated very clearly within the framework of capitalism and had no hesitation in putting the needs of capital before that of the working classes, also acknowledges that, quote, the fact that the reforms were introduced in Britain under a Labour government, which had been elected with a massive majority on the back of the defeat of fascism, meant that working class people felt a real sense of ownership of these reforms, and that, in a very real sense, the welfare state was a product of the class struggle that changed the balance of class forces in Britain, end of quote. As is well known, however, the Thatcher government waged war on the trade unions, culminating in the infamous repression of the miners' strike of 1984 to 1985. To a significant extent, the Conservative war on the trade unions was waged through the legal system. As Dale Lydon writes, quote, between 1980 and 1993, there were 6 Acts of Parliament which increasingly restricted unions' ability to undertake lawful industrial action. Secondary action, better known as sympathy strikes, was outlawed, and picketing was restricted. Ballots were needed for official industrial action from 1984, and these had to be postal from 1993. Although unions have learned to use ballots as part of the negotiating process, they have imposed increasing financial costs, while the requirement to give employers 7 days' notice further reduce unions' ability to respond quickly and potentially reduce the effectiveness of any action they took. Employers could also gain injunctions from the High Court to stop unions undertaking strikes if there was any doubt as to their legality, facilitated by the increasing complexity of strike law. This tactic led to many strikes being abandoned, though if a union persisted, they could be charged with contempt of court and fined or even have their assets seized. Injunctions gave employers a more immediate remedy than suing unions for damages, something that became possible again from 1982, a return to a situation before 1906 Trade Disputes Act, when unions were at the mercy of the courts. The Conservative government also interfered with the running of unions' internal affairs by compelling certain forms of election for executive committees and general secretaries, irrespective of the traditions of individual unions. The incoming Labour government kept almost every aspect of Conservative trade union law. The new relationship with unions was dubbed fairness, not favours, as if the right to strike was a favour. End quote. One very important change was the outlawing of the closed shop agreements, in which an employer and a trade union agreed that all workers must belong to the union in order to be employed. These were outlawed by the Employment Act of 1988. Tony Blair's Labour government deliberately chose not to roll back the Conservatives' assault on the trade unions. The 1998 White Paper, Fairness at Work, said, "There will be no going back. The days of strikes without ballots, mass picketing, closed shops, and secondary action are over." The war on trade unions continues today, with the Strikes Minimum Level of Service Act 2023, passed last year, that restricts the right to strike. This is another nakedly classist measure. Rather than conceding better pay and conditions for striking workers, the government has moved to suppress them through the legal system, just as it did in the 1980s and 1990s. This is not to say that all the changes to employment law since 1979 have been bad. On the contrary, we've seen important progress in a lot of areas. For instance, the National Minimum Wage Act of 1998, passed under New Labour, which introduced a minimum wage for the first time. The New Labour years also saw the expansion of legal protections against discrimination in employment, culminating in the Equality Act 2010, a piece of legislation which is vitally important, albeit flawed. But that doesn't change the fact that the UK's labour market is heavily weighted in favour of employers against employees. Increasingly, many workers work in precarious employment, the gig economy, jobs in which they are nominally self-employed and lack entitlement to the national minimum wage and other basic employment law protections. The national minimum wage itself is not enough to live on. Since 2012, employees cannot claim unfair dismissal until they've worked for the employer for a qualifying period of 2 years. And with the lack of legal aid for employment and tribunal proceedings, many employees cannot afford effective access to justice. Which brings me on to access to justice. The third and final theme of this lecture, which is legal aid. Much like council housing and the NHS, legal aid is a vital public service. Most people in their lifetimes will encounter circumstances in which they need a lawyer. That can arise in a wide range of situations, from being accused of a crime, going through a divorce, being discriminated against, or being unfairly dismissed at work. And anyone who's seen or been a litigant in person, seen them in action, will know that navigating the legal system without the assistance of a good lawyer is no easy task. The rich, of course, can lawyer up, afford the best lawyers. But for most of English history, if you were poor, legal representation was an unaffordable luxury. The 20th century saw the introduction of publicly funded legal aid. Criminal legal aid was first established by the Poor Prisoners Defence Act of 1903, which introduced legal aid for trials on indictment. The Poor Prisoners Defence Act 1930 extended the availability of legal aid, which was available as of right in murder cases and available in other indictable cases where the courts considered it desirable or in the interests of justice. Legal aid could also be granted exceptionally in magistrates' courts. A system of means-tested civil legal aid was introduced by the Attlee government in the Legal Aid and Advice Act 1949. It extended to most kinds of civil proceedings, with certain exceptions such as defamation. I suppose only the rich can be defamed. In explaining at the second reading why the bill was needed, Sir Hartley Shawcross, the Attorney General, recounted an anecdote about a famous 1845 case on bigamy. Quote, "Then there was the very famous sentence imposed by Mr. Justice Mole in a certain bigamy case. A hawker convicted of bigamy urged in extenuation that his wife had left her home and children to live with another man, that he had never seen her since, and that he had married the second wife in consequence of desertion by the first. Mr. Justice Mole said, quote, 'I will tell you what you ought to have done in those circumstances, and if you say you did not know, I must tell you that the law conclusively presumes that you did. You should have instructed an attorney to bring an action against the seducer of your wife for damages. That would have cost you about £100. Having proceeded thus far, you should have employed a proctor and instituted a suit in the ecclesiastic courts for divorce a mensa et thoro. That would have cost £200 or £300 more. When you had obtained a divorce by mensa et thoro, you only had to obtain a divorce vinculo matrimonio, That procedure might possibly have been opposed in all of its stages in both Houses of Parliament, and altogether those proceedings would have cost you £1,000. You will probably tell me that you never had 1/10 of that sum, but that makes no difference. Sitting here as an English judge, it is my duty to tell you that this is not a country in which there is one law for the rich and another for the poor. Then he added, "You will be imprisoned for 1 day." That was a considerable time ago. End of quote. Sir Hartley was actually wrong about this. According to the research by Rebecca Probert, the version of Mr. Justice Moore's remarks he recounted is mythical, and the bigamist in question was sentenced to 4 months, not 1 day. Clearly, Mr. Justice Moore wasn't as insightful a social commentator as later reports suggest. Even if these sentencing remarks were fictitious, they were an incisive satire on the state of the English legal system and the unreality of expecting the poor to have recourse to legal remedies that they could not possibly have afforded. Of course, by 1949, divorce had been considerably simplified compared to 1845, but it was still out of the reach of many poor people. As Sir Henry Brooke explained, divorce work in the High Court was the first target of the new legal aid scheme, with the legal aid gradually being extended to other areas of civil work. The 1949 Act was later replaced with the Legal Aid Act 1974, and then the Legal Aid Act of 1988. The scheme did see a tightening of eligibility, according to Sir Henry Brooke, whereas 77% of households were financially eligible for civil legal aid in 1979 to 1980, only 47% were eligible by 1994 to 95. And by 2007, under New Labour, only 29% were eligible. But the biggest damage to legal aid was inflicted by the Conservative Liberal Democrat coalition government. The Legal Aid Sentencing and Punishment of Offenders Act 2012 significantly narrowed the scope of legal aid, taking many areas of legal work out of scope altogether. Even when a person does have entitlement to legal aid, whether they can actually find a legal aid lawyer is another matter. The state of legal aid in England is dire. Many parts of the country are known as legal aid deserts, where there's a chronic shortage of provision. Research by LexisNexis found that 12.45 million people live in legal aid deserts for housing law. That means the area in which you live, you cannot find a lawyer that deals in that area. 2.12 million people live in legal aid deserts for criminal law. Can you believe it? You live in an area and you can't find a legal aid specialist in criminal law. 1.09 million people live in legal aid deserts for family law. According to the Law Society, the rate of advice agencies and law centres now doing legal aid work has dropped by 59% since 2013. Legal aid rates are often insultingly low, especially in crime, making it impossible for lawyers to generate an adequate income to cover their their costs. After the government rejected the recommendations of the independent review of criminal legal aid in 2022 and imposed real-term cuts on solicitors' legal aid rates, the president of the Law Society gave the following stark warning, quote, "Our warning to those entering the profession and considering a career in criminal defence practice is that given the current situation with criminal legal aid, it is highly unlikely that you will be able to generate a reasonable professional income from this work." In short, the government is refusing to pay criminal defence lawyers enough to keep the lights on. Once again, government policy has delivered one law for the rich and another for the poor. So let me come to the conclusion of this lecture. In this lecture, we've looked at how legal policy in the past few decades has widened wealth inequality and promoted the class interests of the rich at the expense of the poor. I could finish this lecture in a conventional way by giving a wish list of the kinds of reforms in the law that I would like to see, such as massive council house building programs, rent control, a universal basic income, and proper legal aid system. But that would be fairly pointless in our current political landscape. There seems to be little chance of these policies being enacted. So instead, I want to finish this lecture by talking about the moral responsibility of lawyers. A lot of lawyers would agree with many of the criticisms of our legal system I've made in this lecture, but many of them would shy away from the suggestion that lawyers themselves bear any responsibility for it. After all, they would say, a lawyer's job is to represent their client whether or not they agree with their client's cause. And I, of course, understand that point of view. And there is some truth to it, especially for lawyers such as myself, a barrister, who are bound by the cab rank rule. And that for those of you who do not know what the cab rank rule is, I am like a taxi cab. If you flag me down, I have to do your case. But I would also sound a note of caution. Lawyers wield a lot of power in our society. As a lawyer, you do have a significant amount of agency in what kind of practice you have. And I believe you do have a moral responsibility to care about the consequences of your work. What I've sought to show in this lecture is that the law is inherently political, and too many lawyers end up going into fields of practice where they are effectively waging war on the poor on behalf of the rich, or fighting, or whether that by defending the government's policies in court, or fighting to evict tenants, or prosecuting the poor. I would encourage the next generation, those of you who are starting out on your careers or thinking about a career in law, to think about that when you make your decisions. Thank you.
Thank you very much. We've got quite a few questions coming in on Slido, and we will have the microphone here in the hall too. I'd like to start with one which is sort of building on from that, from Alana, who says, do you think this division between the rich and the poor will inevitably continue due to our current government and potentially next government?
Yes.
Short answer, only prevented by lawyers then?
What is clear, and you can see, it's clear that this lecture has been quite political, but that's the whole point of this series. It's looking at law on a hard edge, and as I've made clear, there hasn't been much difference between the two major parties. since 1979. So in that sense, this isn't a political lecture because, my views of both political parties are fairly equal. And I cannot see, particularly given some of the policies and the mirroring that the current Labour opposition are doing, very different to the Conservatives. So my answer remains a yes. I don't think there's going to be much change.
And
Next.
Luana's asking, how can the legal education and training programmes adapt?
When I was training, there were so few of us who wanted to do socially progressive law. Out of 100 young trainees, I think about 4 or 5 of us were interested. Everybody else was interested in commercial, tax, that sort of work. And what I'm saying is I want the next generation to really think about the law that they go into. And I think that, that will help to bring about change.
Let's hope so, yeah. Moving on to housing now, we had a question from Hazel about, has English law particularly made renting a long-term home seem undesirable in the UK, almost inferior, unlike in European countries where there is long-term renting?
Yeah, I think it has. As I touched upon in the lecture, the deregulation of rent controls and tenancies with the abolition of the 1977 Rent Act, the introduction of the Housing Act 1988, the concept of short holds. We can see, can't we, very, very clearly that it is a landlord's market. And with that, houses, flats, apartments are not seen as homes, they're seen as commodities, investments, they're seen as pensions. And therefore, the fact that there is a landlord might have a family, and I'm not talking about situations where you've got difficult families or difficult tenants who are not paying. I'm talking about situations where you do have people paying, that suddenly putting them out because you want to raise your rent to by a third, double the rent, whatever, is just shocking. And you don't have that in Europe or certain parts of Europe. I know that countries like Germany and France, they have a very large rental situation where the rights of tenants are respected, and they don't have that thing that the British have. You've got to own your home.
Yes, and then we don't have the situation where as everyone knows, young people nowadays can't afford a home and are staying at their parents' home for years and years, and it's affecting their whole life going forwards, which is a very poor thing, I think, for politicians to have created for us, actually. Lovely. Let's take a question from the audience. Safi, one right next to you.
Hi, thanks very much. That was fantastic. I was wondering on housing and about the shortage. As a young person, who it seems quite far away, whether sometimes rights that were given originally in a benign spirit are actually counterintuitive, and particularly with Attlee, the Town and Country Planning Act in 1947 allows these local communities to oppose developments, and in the modern day that means generally elderly homeowning pensioners are nixing developments, and now we have 4.3 million missing homes. So I know there's a balance there. You want to give communities control, but where does the balance lie? And is it wrong to say something should be taken out of local control, should be almost imposed from above for some sort of greater good and building target? I don't know.
It's an interesting concept. Yeah, and I suppose, and just to add to that, just in terms of developing sites for building, there's so much law restricting building on green sites. That's a similar issue. I do think that government policy needs to change to reflect and to encourage more building of council homes. I think that would be a great step in the right direction. Unfortunately, the figures that are being mooted are just so minimal that we're nowhere as close to the home building levels that we had in the 60s, 70s and 80s that I've touched upon in this lecture, and I just can't see either the present government or the potential next government adjusting those figures. So yeah, the answer is I agree with you that a relook at the balances, it would be a good thing.
Yeah. One question is, the title was Wealth Inequality, English Law's Unintended Legacy, but it sounds like you say it was very intentional by the rich, and I'm just wondering where the unintentional comes. And also in response to what you were saying about the German and French having much better rented, do you think we're copying the Americans too much?
Right, okay, so the first part of your question, you detected the irony. And the second part of your question, are we following an American model? I think we are. The short answer is I think we are. We have this notion about home ownership and investments in property, and so I think we are following an American model probably too much.
Lovely. I think that's all we've got time for. Leslie's got an important engagement with the jury on TV. I think we probably all do too. Watch it. So I'd like you to join me, please, in expressing your great thanks to our Professor Leslie Cummings.